Hello, everybody, and welcome to session 7 of the PMT Risk Management and Insurance course for 2023. In this session, we'll take you through the assignment, and I'll give you just a few tips that I suggest you take into account in approaching the assignment. When you get to this stage, you need to at least have read the manual and watched all the videos. You are all admitted legal practitioners, whether you be attorneys or advocates or with trust accounts, and you cannot approach the assignment the same way that a first-year university student would approach it. So please read the questions carefully, write well-reasoned answers, and set your answers out as you would in a legal opinion. In previous years, there have been candidates who have said that they have not drafted a legal opinion and have never seen one. If that is the case, please have a look at a Supreme Court of Appeal judgment, any one of the recent judgments from the Supreme Court of Appeal, or even the Constitutional Court judgments, and see how the judges set out their legal reasoning. That will give you an idea of how to do it. Supreme Court of Appeal, judgments that are on average 30 pages or less. That would also be in line with the guidelines from LEAD for the assignment of the 25-page maximum. When you write your assignment, please cite the relevant authorities. Don't just copy and paste. If you refer to the material that's not yours, please cite the authors appropriately. Your referencing style will be up to you, whether you choose to go the Harvard referencing style, for example, or the South African Law Journal referencing style, or use the referencing style that's used in the Supreme Court of Appeal. It's entirely a matter of your personal preference. Don't try and attempt this assignment at the very last minute and think that you just copy and paste material from the internet and pass it off and think that it will be enough to pass. It will not. Last year we had a few candidates where it was clear that they just used Google to try and find answers, and just went to whatever popped up, they copied and pasted. They went to websites of insurance companies, whether they be local or international insurance companies, and just copied and pasted from there. That is not enough to do it. The internet is a useful tool, but always remember that if you just type in a search into Google, the material that comes out may not necessarily have been written by an attorney or somebody with any legal training. It may not be up to date, may not be accurate, and in some instances it's not even applicable in South Africa. There are people that used Wikipedia, and while Wikipedia may have its uses elsewhere, it's not good enough for your assignment. If you refer to the LPWF policy, please cite the applicable clauses. Look out for risk management and insurance issues that pop out in each question, and refer to them. Use case law, the statutes, other authorities. The point of this assignment is for you to demonstrate your understanding of the risk management in a legal practice. This is not the type of assignment where you can get by winging it. So don't think that at the last minute you can just put something together and that is maybe relevant or not, and you think that that would be enough to get by. It will not. If you still have difficulty at this stage understanding legal concepts like contractual liability and delictual liability, please go back and read the textbooks and the cases on that in order for you to understand it. One of the big risks facing legal practices is the decline in the amount of research on substantive law that some legal practitioners do. It's easy for us to identify those assignments that have been hastily put together at the last minute, or even those who do have copied from their colleagues or people that decide to phone the LPIIF. We had an instance last year where a candidate phoned one of the members of the executive team of the LPIIF and asked him questions, but she was really trying to get him to point her in the right direction and to give her the answers to the assignment questions. He quickly picked that up. She claimed, first of all, to have been an insured who was facing a claim. And when he asked her a few questions, that it was clear that she was not. She then claimed to be acting for a plaintiff in a matter and wanted guidance. When he asked a few questions and she couldn't answer, it became clear that, well, after he asked her directly, she said she was doing research for her PMT assignment. Read the manual. Should be your starting point. The manual, you exclude the policy and the other annexures, is really the same length as an SCA judgment. As lawyers, we are obliged to do a lot of reading. It's incumbent on us to read it as much as possible, but to read the equivalent of one judgment to get through an assignment, I think is not asking for much. The manual also has useful information that will assist you both in this assignment as well as in your practice. Watch all the videos. Don't try and do a spotting exercise to decide which ones you'll watch. You'll be caught out. The LPIIF website, as well as the practice management column in the Rebus, have a lot of useful information. Have a look at that material. You don't have to troll through thousands and thousands of pages. If you look at the titles of the various articles, you'll be able to see what the content is. And if you were to use those to help you with your assignment, it would be easy. The poor standard of some of the assignments in previous years are related to some of the issues that are mentioned. How you tackled your assignment will say a lot about how you'll tackle risk management in your practice. If you do not put effort into this assignment, you are hardly likely to put effort into risk management in your practice. Sorry, and that will show up when you are faced with one or more claims, or when you're faced with regulatory action for breaching the rules. Good luck for your assignments, and you'll see that The 4 questions are really straightforward. They focus on the 4 main risks: prescription, theft, understanding the basis of liability of an attorney for professional indemnity claims, and cybercrime. All those have been covered in the manual and in the presentation. I'll not answer the questions for you, but I'll just give you some pointers. Prescription has been covered in depth, and you can look at the resources in the manual and those in the presentation. Just to jig your memories, you remember we spoke about risk measures, risk mitigation measures such as registering all time-barred matters with the LPWI prescription alert unit, not taking instructions close to the prescription date, obtaining all the necessary information from the clients as early as possible in the matter, acting without procrastination, suggested measures like having an adequate supervision system in place in your firm, about file audits, educating staff on the law relating to prescription, when prescription starts running, when it's suspended, and when it's interrupted. So please, I think that is it's go back to those, and you'll be able to answer that question. With theft is also that has been covered in detail in the previous videos. I think you can you'll be able to, if you watch those, you'll be able to get through this question successfully. Professional indemnity claims and the basis for liability, that has also been covered extensively in the presentation. Just on that question 3, in order to show the markers that I am up to date with the law, I'll refer to those 2 cases that you see on the bottom of this slide: Hartog versus Daly, Howden versus ENS. Hartog versus Daly, it's a cybercrime related matter, but the claim was framed in contract. The Howden versus ENS, the claim there was framed in delict. And then you'll remember the other cases that you'll get from the manual and the videos: Slomovitz versus Koch, Honey and Blackenberg versus Law, Rampau versus Brett Williams and partners, Mlenzana versus Goodrick and Franklin, etc. All those cases are referred to. You do not need to refer to every case, but you can just get the general principles. Lastly, cybercrime. We've also covered that, the issues of verification, knowing the verification of instructions and verification of bank account details before you make the payments. Once again, in order to really impress the examiners, I would refer to those 2 judgments: Hartog versus Daly and Howden versus ENS. Do not, please read them. Don't just refer to judgments if you haven't read them. Reading those 2 judgments will really assist you in answering this question. At this stage, haven't received confirmation yet, but the indications were that an appeal was being considered in the Howard versus ENS matter. But up until the appeal is processed, if the appeal it does go ahead, the judgment as it stands from the Gauteng division will stand. So please refer to it. In tackling the cybercrime related question, as I said, the verification of the instructions to pay is very important. Calling clients in to physically come in with the proof of their banking details, taking when getting the banking details as early as possible in an instruction, preferably when you are taking the stage that you are taking the accepting the instruction would also assist. Remember the references to the internal control measures that need to be implemented. Rule 54.14.7, that's 54.14.7. Rule 54.13, that's 54.13, which prescribes that you must verify the banking details and any reported changes to the banking details before the payments are made. Doing the verification, the verification of the bank account details when you do your FICA verification process. Prominent notices on your correspondence that your banking details remain the same. If we look at the Howard versus ENS, yes, it's now now it also be necessary to do that in all correspondence, telling clients and third parties as early as possible that your banking details have to change and alerting them to the business email compromise and other risks. If a firm falls victim to the scam, and in the result there's a shortfall in the trust account, this will be a violation of Rule 54.14.8. That's 54.14.8, and the trust account will be in debit. 54.14.9. You must then immediately report that shortfall to the Legal Practice Council as required in Rule 54.14.10 and immediately make up the shortfall. In answering this question, and in order to show the markers that I really know what cybercrime is, in addition to what I've mentioned, I would just put a few notes regarding that. I won't go into detail, but just to say that I would investigate whether there's any breaches in respect of POPIA that I need to report, whether there are any obligations for me to report also in terms of the Cyber Crimes Act or any other legislation. And I think that is it from my side. I will regularly post some further guidance on the eLeader platform. I will be available to answer assignment related questions that's related to the content of the assignment, not administrative related matters. And with that, I wish you all good luck and I hope that you have learned some some issues relating to risk management, and that you will also apply them in your practices and not forget them after you've completed the PMT course. Thank you.